For today's legal reality, where I kind of give you a behind the scenes of how lawyers work and how some of the sausage is made, I'm going to answer a question that I'm asked all the time, which is like, how do lawyers get paid? How do all these fee arrangements work? And this is something that I have taught before to people who were planning to be paralegals. So I thought I would go ahead and teach it to you. So if you've always wondered, now you'll know. So there's really three ways that lawyers can be paid for their work. There's a fourth one that's sort of an asterisk that I'll tell you about. But before I get into any of this, I just want to remind people that although it doesn't oftentimes get portrayed that way, practicing law is a service job. It is a job where you are paid to perform a service, just like doctors, right? You are not paid for your output. You are not paid for the documents you create. You are not paid to build anything. You are paid for your services, and your services are provided in your time. Now, there are different ways of calculating what those services are worth. And these are the top three. But just remember, like lawyers are, we're service professionals. And I think that sometimes people forget that. I think that lawyers sometimes forget that, we are in a client-based business. We are here to serve clients. So these are the top three ways that lawyers get paid. The first one is a flat fee, which is exactly what it sounds like. A flat fee is when a lawyer says, you pay me X amount of dollars and I will do X amount of thing. I have a good friend who is a personal bankruptcy lawyer. He does personal bankruptcies, and he's $5,000 flat fee. You pay him $5,000. He will file your bankruptcy. He will get it all the way through the courts. He will get your debts discharged and move you along out of his office. And it's $5,000 no matter how long it takes. Now, this is obviously calculated really carefully by the lawyers because it is not dependent on how long it takes. Some cases that cost $5,000 take 20 hours, and some of them take 200 hours, right? Because you're not charging people by the hour, you have to calculate the right amount. You have to find just the right middle ground of like how much is worth it, and will the smaller cases and the bigger cases balance each other out. That is obviously the easiest, right? You pay me X and I'll get you to the finish line regardless. Now, there is such a thing as a flat fee plus, where someone says, I think this is going to be a flat fee, but if it ends up being more complicated than you're telling me right now, I get to start charging you by the hour, right? You can say 99% of the time, these kinds of cases are, I get them done in 20 hours and you pay me $5,000. But if I find out halfway through this case that you've got 3 LLCs in the Caymans that I didn't know about, we're going to start charging you by the hour. And you would put that in an engagement agreement, which I'm going to show you an example of. The second kind of way that lawyers get paid is by contingency, right? And this is where the client pays nothing to the lawyer up front. And the deal is that whatever we recover at the end of the case, the attorney gets a piece. Now, obviously, this only works for attorneys who are representing plaintiffs. It only works if you have an affirmative claim where you are going to get money at the end. If you are a defendant, right, the best possible thing for a defendant is that there is no verdict, or there's a defense verdict, no money changes hands. So a percentage of nothing is nothing. This is a way that many personal injury attorneys get paid. And the reason that they can go along the case without getting any money in on their end is because they do it in high volume, right? So if you think about it, they're not getting paid. They say, I'll get a percentage of whatever you get at the end. And it depends on the state, by the way. Some states in most states, there's a maximum, like some states are 33 1/3%, right? You can take a third. I think there are some states that are as high as 50%. But you can negotiate with the lawyer going in how much you're willing to have them take. But even if there's a big pot of gold at the end of the rainbow, this attorney has costs all along the way, not just their own time, but they have to pay filing fees. They have to make copies. They have to pay payroll. They have paralegals and legal assistants and mailroom people who are working on this, and they have to pay those people along the way, right? And the way that they do this is typically by volume, by saying, I have, 600 cases and they're being settled all the time. So money is always coming in to sort of cover the expenses for the new one we just took where there's no money yet. This is also part of the reason why personal injury cases settle so much, even more so than other cases, because there is this constant need by people who are doing that kind of plaintiff's work. They need money coming in the door for cases that are moving to cover the expenses for the cases that are coming in the door that haven't started yet. Generally speaking, now again, every state is a little bit different, but generally speaking, paralegals cannot share in a contingency fee, right? So if you are working on a case and you have all the timekeepers, all the people who are able to bill for their time, that is typically attorneys and paralegals. Paralegals cannot share in the contingency fee because they are not engaged in the practice of law, right? So if an attorney takes a case on contingency, okay, and gets $1 million verdict, and they've negotiated with the client to get a third of that money, right? They get this huge amount of money. They cannot then cut a check to the paralegal and say, here's your cut of our contingency fee, because that would violate the rules regulating lawyers and the way that lawyers get paid, because you are paying a non-lawyer part of a lawyer's contingency fee. However, there are ways to get around that, right? You just put the money in an account and you come up with some cute thing and you say, oh my God, you did such a great job this year. Here's a humongous Christmas bonus, right? But just know that generally paralegals cannot share in those fees. Generally, paralegals are on salary and they get paid what they get paid. The third one, which is the most common, is just paying people by the hour, right? This is sort of the standard way that it's done. And this is where attorneys and paralegals who are working on the case have an hourly rate, and the client pays them per hour or per section of an hour a set amount, and you calculate the amount of time times the rate, and that's what the people get paid. Now, because of this, attorneys and paralegals working on the case have to keep track of every single section of an hour that they work in all day long, every single day. And depending on how the case is billed, it can be billed in quarters of an hour, meaning every 15 minutes. You round up to the next 15-minute mark, or it can be billed in tenths of an hour, which is every 6 minutes of your day. Now, one of the real benefits of contingency work and flat fee work, of course, is that you don't have to do this. You don't have to keep track of every 6 minutes of your day. Sometimes contingency fee lawyers will keep track anyway, or they'll keep track kind of loosely, because if they are in the type of case where they might be able to get an attorney's fee award, if they win and the other side loses, they might be able to get their attorney's fees paid in addition to their cut of the money. And then you have to have the invoices to show the work that you did. So depending on the type of case, sometimes contingency fee lawyers will keep track of their hours just kind of loosely to have something there. But lawyers who work by hourly rates, which is most lawyers in law firms, are going to have to track their day all day long. And I can tell you, as someone who started out working in a firm where you had to keep track of tenths of an hour, so every 6 minutes of my life, switching to a job where I didn't have to keep track of hours at all, and then having a hybrid job where hours meant something but not everything. Once you get this into your brain, it never stops. To this day, I look to see how long every single phone call I've had has been, how many minutes it took, even if I'm talking to my mom. because you just get trained to know, okay, I have to look at the phone afterwards and be like, okay, that was 12 minutes. Okay, point two. And I'm going to show you some examples of bills like that. But it just becomes part of your thinking and it is exhausting. And there's a reason why people hate it. But it is probably the most accurate and fair way to represent what you've done because you have to say exactly what you were doing, right? The fourth thing that I don't put on here, actually, there's probably a fifth. The fourth thing that I don't put on here is that you can engage in a trade. I mean, you can say, I'll do your legal work if you do something for me. There are some ethical rules for lawyers about like you cannot have a case contingent upon you're getting an ownership interest in a piece of property if the piece of property is in the litigation, right? Like there's some like conflicts of interest and ethics there, but there's nothing that says that you can't bargain or barter for your fees. I mean, we had Mr. Nag and I had a contractor who did work for us for 20 years. He retired. We miss him so much and became a really good friend. And he just had some issues with his business. And he was like, can you help me out? And we're like, tell you what, we want to put some new floors in our basement. How about you put the floors in the basement and we'll do the legal work? And he's like, okay. So that's what we did. So you can barter for legal fees as well. The fifth one is, in-house lawyers, and in-house lawyers get paid a salary. They're just like every other executive. They get paid a salary. You get paid X amount of dollars because you are getting paid to be there all the time for your work for that client, whatever company you're in house with, to be their lawyer 24 hours a day. So you get paid a set amount, and that's how you get paid. So how do lawyers get hired? How do clients get to lawyers? It happens all the time. It's mostly through referrals. Most of the clients I have ever had, most of the clients Mr. Nag has ever had, is somebody refers somebody. Oh, I know somebody who does that work. I refer people to other lawyers all the time. Do you know anybody who does X? Yes, I do. Call Peter. He's great. So it can be word of mouth. The only thing that is generally prohibited by ethical rules is that you can't seek people out. You can't ambulance chase, right? But people do it anyway. You're not supposed to be able to solicit clients. You're not supposed to be able to walk up to somebody that you've never met before and be like, hey, do you need a lawyer? Did you know I'm a lawyer? I could help you. But people have found ways around that, including the way they do their billboards. And those rules don't apply, by the way, to things like class actions where they are trying to find, do you have mesothelioma? And did you work in the coal mines of West Virginia from this year to this year? That's not solicitation because you're genuinely trying to find people. But I will tell you in 2026, those rules are awfully lax compared to the way they were when I first started practicing law. When I first started practicing law, it was just like, you don't do that. Now, if you network and you meet somebody, you can then send them an email and say, hey, I saw you have a case. Can I help? But you did not just like email or call or send people letters out of the blue. Now that happens all the time. I don't think it's very well regulated. But once you get to a lawyer and you think, okay, I think this is the lawyer that I'm going to hire, the very first thing they do or should do, and if they don't, it's a red flag. The very first thing they do is run a conflict check. Because if the lawyer is in a law firm, and if you're hiring them, they probably are, and it can be a law firm of 1 or a law firm of 2,000, the very first thing that lawyer has to make sure is that they don't have a conflict of interest in the case. If you go into a lawyer and say, I want to sue Bank of America, that lawyer then has to go through their files. A lot of times there's somebody on staff who does this. In big firms, there's entire departments who do this to make sure that the firm is not representing Bank of America, right? In other words, are you representing the adverse party? Or if you are, does that create a conflict with taking on this new case? And that is a whole matter that is super complicated, and I can talk about it one day if you want to. But the bigger the firm, the more the conflicts, right? If you have a giant firm that represents a whole bunch of institutional clients, it's going to be really hard for you to take on plaintiffs' cases where they're suing those institutional clients. Now, just because a firm represents somebody who might be involved in the suit does not mean that's necessarily a conflict of interest. What if it's on a totally different matter? And there's absolutely no chance that it's going to change the power dynamic in the case. But a lot of times you have to work on that conflict before you can even take the case on. This happens to Mr. Nag a lot because he represents a lot of banks. And anytime he is dealing with a client, let's say a developer or some kind of company, and part of their dispute is with a bank, he has to then go to the bank and find out if that is a conflict of interest, right? And or, do you mind if I represent this person? The client can waive the conflict. So long story short, the very first thing that a law firm, a lawyer should do is do a conflict check. And if you get past the conflict check, that's when you do everything else. Once you get to the next stage, then you are looking at how you are engaged. And every lawyer should have some kind of engagement letter. I'm going to share with you some documents here. They are real documents. They are from different firms, but they are real documents that I have redacted the information out of. All of these documents come from matters that were for clients who are subject to public records laws. So I am showing you documents that are public. They'd actually be public unredacted. I'm just, trying to give maximum, hiding of anything that could be problematic here. But just so you know, I'm about to show you some real stuff, but I just want you to know I'm not showing you anything that's privileged. I'm not showing you anything that's confidential. All of these things are public records, okay? So this is an example of an engagement letter. And this is a pretty basic one where it says, the very first page says, you've hired me to do X, right? And then it talks about, these are sort of the main points. Here's how much I get paid per hour. This is a very low one because it's for a public client. Here's how much I get paid. If I need other people, here's how much those people get paid. It does not have to say their names. It just says, this is how much these other types of lawyers get paid, right? Then you see in there, it says, we reserve the right to modify these rates annually. Most law firms every single year get together and decide what they're going to do with their rates, and they publish new rates. And shocker of all shocks, they almost always go up, right? Because the market changes and so the rates change. So this engagement letter says, you're going to pay me $275 an hour, but next year it might be $3, just so you know. The good firms will notify you of that. The good firms will send you an email and say like, hey, just so you know, we have new rates and now we're charging X dollars an hour. And then it includes other potential people who could be involved in the case. It also notes that there might be a difference in the rates depending on who's paying the bill. A lot of large organizations, lawyers are paid through insurance policies. And insurance policies will have limits to the hourly rates. So sometimes there are two different sets of hourly rates. One set of the insurer won't pay more than $275 an hour. But if it's being paid by the organization or the corporation directly, we expect $550 an hour. That's what this one says. If you're going to pay us directly, we're $550 an hour. That's what we get paid by the general public. We understand in this case, our representation is being paid for by an insurance company and they'll only pay $275. So that's a whole wrinkle that can get in there too. Then they cover the issue of costs. Costs are tracked differently than fees. Costs are not attorneys' hours. Costs are hard things that you have to pay to litigate a case. And some of you have seen these in the Lively documents. Costs are things like copy paper, literal binders, filing fees, deposition transcripts, right? These are things that you need to litigate a case that can be charged to the client, but they are not an attorney's brain work. An attorney's brain work is what attorney's fees are for. Back in the day, when I first started practicing law, when you had to pay for long distance phone calls were on cost estimates, right? They would literally have to punch in a matter number in order to make a long distance phone call. I don't think that happens anymore. But this can be research, this can be mail, this can be all of those things. And those are tracked separately. And they pretty much are what they are. Now look at paragraph 5 here. This one I think is important. Not all engagement letters have it, but I think they all should. And that is this language that is just clear enough that you're going to tell us the fucking truth. If you want us to do this work, you're going to tell us what is going on. You're not going to lie to us. You're going to make people available to us if we need them as witnesses. Like, don't make this hard. And this is the thing that you put in the agreement, because down the road, if the client isn't doing these things, you can pull them out and say, remember when you agreed to do that? If you don't do this, we're not going to represent you anymore. Then you have things like document retention. This is sort of varies from state to state and firm to firm. But then down there at the bottom, it talks about termination of representation. And this one just happens to refer to the bar rules of that particular state. But every state bar has rules about terminating the representation of a client, when you can do it, how you can do it, and what happens to the files. Because when a lawyer either quits a case or is fired, a lot of times the biggest fight is a client will call and say, you're fired. Send my files to my new lawyer, Bob. And you say, I'm not sending shit to Bob until you pay me what you owe me, right? That is when the bar rules of that particular state step in and tell you what you can do. So the first thing that happens when you hire a lawyer is that you get some kind of engagement like this. This one's pretty short. It's like 2.5 pages long. I have seen them be much, much longer. I have seen them be much more complicated. It depends on the case. It depends on how complex the case is. Before I move on, a word about rates, like up there in paragraph 2. That could be a whole video in and of itself, because firms will publish rates, but rates are typically pretty negotiable, right? Lawyers will have a set rate, but then they can negotiate with clients a discount of that rate. They can say, you know what, can you give me a 20% discount because I'm going to send you 3 cases instead of 1. Some institutional clients will require discounts just so they can say to their shareholders that we got a discount. So if you ever go in to talk to a lawyer and they're like, this is how much I am an hour, you can say, is that discountable? You can negotiate those rates to a degree as long as you don't insult them. Like, I'm not paying you $1 more than $50 an hour. Lawyers can be like, go fuck yourself. Go find yourself another client. But if you say like, hey, I think I've got a couple more people I can refer to you. Can I get a discounted rate? They might listen. And if you are referred to a lawyer by somebody you know, there is always a friends and family rate, right? I'm a friend of so-and-so. She sent me to you. Is there a friends and family rate perhaps? Ask. It can't hurt. The worst they can say is no. So what do the entries actually look like? I'm going to show you a fake one, and then I'm going to show you a real one. This is a fake one. This is one I use when I am teaching paralegals how to keep time. Okay. So this is something that lawyers and paralegals who are getting paid on a per hourly basis would do every single day. You would keep a list like this every day, all day long. And in most law firms, clients they have matter numbers. Sometimes it's by name, sometimes it's by number. I did both here. And this is on tenths of an hour. So every 6 minutes, you're billing for what you did. And all day, every day, you write down what you did and how long it took. So if that says telephone call with opposing counsel regarding deposition scheduling, point 2, that means that took 12 minutes. It took 0.2 of an hour. It took 12 minutes, right? Now, of course, the stuff that's the easiest to write down is the stuff that takes tons of time, right? So if you look at review memorandum of law, that took a whole hour. So you're like, it was like an hour 5, a little over an hour. Those are easy. if you could just do your whole day in huge chunks like that, like I'd spent 2 hours on this and 3 hours, but that is not how the practice of law works, because there's a million little phone calls, there's a million little emails, there's, oh, I got to read this thing. Somebody just walked into my office to ask me a question. And then, of course, there's all the things you do that are not billable, like go to the bathroom and talk about golf, right? So none of those things go on this sheet. But this is how it's done every single day, all day long. It's a real motherfucker. And it really does wear on you after a while. It just becomes something that you're so used to, but that doesn't mean you don't hate it. In terms of how much detail you have to provide, to some degree, that is a matter for the client. Some clients will accept, as we have seen in the Lively case, some clients will accept block billing and very vague descriptions of attention to. I wouldn't. When I have been in-house and I have been the one going through the bills and deciding whether the company was going to pay it, I do not accept shit like that. Some clients will. If you are the client, you don't have to, because you deserve to know what you're paying for, right? When I teach this to paralegals or people who are going to law school to say, here's how you fill out your timesheet, they always say, how much explanation is enough? How much detail is enough? And the answer to that is, put yourself in the position of someone who has to write a check for it. If you're going to ask somebody to write a check for these entries, how much would you need to feel like the check was worth it, right? So for example, for the first one, if it just said telephone call with opposing counsel, but it didn't say what it was about, maybe you'd pay it. It's only 12 minutes. Like, okay. But like, when you're down here at the second to last one, where it says telephone call with client and litigation team, the client was on that call. They know how long it took, right? So you got to be really careful about stuff like that. In my opinion, bills should always be looked at through the client's eyes. Are we giving the client enough information? Do clients ask to have things taken off? All the time. Do clients refuse to pay things by saying that took too long or I'm not paying for that? All the time. Do fees get written off because things were inappropriate or they weren't the right amount of time or the client doesn't want to pay it? All the time. It happens all the time. It doesn't mean you're going to get it every time you ask it, but I can think offhand of maybe 2 or 3 times in my career on both sides of the bill where I have seen a client say, I'm not paying for that, and the lawyer saying, yes, you are, or I'm going to sue you over it, which we'll get to in a minute. So typically, if it's like, why did it take you 18 hours to draft a 1-page order? And you call and go, I'll pay for half. You can negotiate those things. And again, the bigger the firm, the more likely it is that it's going to write it off because it has other money coming in. Want to see what a real bill looks like? Here's one. So again, I covered up specific names. This is a real bill to a public entity. So this is a public record because it deals with finance for construction work. This is an outside construction lawyer working for a company, giving them construction law advice. And you can see in here that this is the kind of lawyer who does block bill, right? He's got multiple things that are happening inside each one of these entries. I'm reviewing this draft of this agreement, then I'm preparing an email about it. But the way that he does the block billing is that everything in the block is about the same thing, right? So in the first entry, he says, I'm reading an email from someone about this contract. And then here's all the stuff I did in response to that email. In response to that email, I looked at the agreement. I considered this stuff. I made recommendations. I emailed it back. I emailed the client, emailed me back and told me do this. And I did the same. So at least it's all on the same topic, right? And that total was an hour and a half. Now, he could have broken that out and said, point 1, receive and review email. Point 2, review architect agreement. Point 5, make recommendations, right? He could have done that, but because these are all about the same topic, to me, this is appropriate. And I do believe this bill was paid for what it's worth, right? But you can see there that it does have enough detail. It's got the names in there. I just happen to redact them so that this can also be checked. If somebody writes in a bill, I did X and Y and Y and Y and Z, and I did this and I talked to this and I did this. If you're the person paying the bill, sometimes you're like, did it really take that long? Did it really take almost 3 hours for you to do the stuff regarding the AIA B101? I don't know. But because it's got stuff in there about emails and calls with other people, you can call those other people and say, how long were you on the phone with that guy? If you want to get picky about it. But you can see all of these entries let you know what the person is doing. He doesn't just say, work on architect agreement. Work on architect agreement, if I were the one paying the bill, wouldn't get paid. What work? What were you doing? Why should I pay you for that? Right? And this is like a $500 or $600 an hour guy. Why should I pay you this kind of money? I don't even know what the fuck you did. So this is a good example of a real bill of somebody saying, here's everything I did. I'm grouping it by the topic, but I'm telling you, I wrote an email, I made a phone call, I prepared this document, I made recommendations, and all of those things are traceable. The things in bills that catch the eye of people like me or other sophisticated clients and executives are when you're charging a lot of money and a lot of time, but we can't really figure out what it is that you did. And that's not to say that there isn't value that you can charge the client for thinking about the case. That is one of the hardest things to bill for is sometimes you're just thinking about it. You know, you're just sitting in your office, drinking your coffee, and you're like, I wonder whatever. You can find a way to bill that time for like strategizing about whatever. It doesn't have to be a written product, but the harder it is to track down, the harder it is to get paid. So what happens at the end of all of these cases? How does the money actually get into the lawyer's pockets? Well, in a flat fee case, most of the time you're going to pay that up front. You're either going to pay it up front or you're going to pay a huge chunk of it up front with some kind of specific plan to pay the rest as you go. But flat fees, a lot of times, are paid up front. With a contingency fee, of course, you're paying nothing upfront. The lawyer has to wait until there's a settlement or wait until there's a verdict. Most of the time it's a settlement to get that money. The way that works is whether it's a settlement or a verdict, the money does not go directly to the client. The money goes to the lawyer. So, and this is whether it's a contingency or not. This is whether it's a contingency or you're getting paid by an hourly rate. It doesn't matter. If there is a settlement or if there is a verdict and an award of damages, the vast majority of the time, I'm sure there are exceptions, but the vast majority of the time, that money is going to go into the lawyer's account. It's called a trust account. And lawyers are required to have trust accounts where they separate client money so that they can tell exactly what money is for what client. For litigators, this is all going to come in the form of settlements and damage awards. If you're a real estate attorney, you're going to use your trust account to put escrow money in for closings, right? It depends on what it's for. But there are incredibly strict rules for lawyers and their trust accounts. And people who get disbarred, depends on what state you're in, I'm guessing, but most of the lawyers who get disbarred either ghost their clients or steal their trust account money, right? The rules are very strict. So if you are on a contingency and you get a percentage of whatever your client gets, that money will come from the insurance company or the other side or whoever into a lawyer's trust account. And then the lawyer will take their part and then cut a check over to the client, not the other way around most of the time, right? So the lawyer gets the money. Let's say you get $1 million and the lawyer's like, okay, I'm taking my $330,000 contingency fee. And then they write a check to the client for the remaining money. If you are not on a contingency and you are being paid hourly rates and you get a settlement or you get a damage award, How that money is allocated is going to depend on how up to date on their bills the client is. If the client is up to date and all the bills have been paid, then the law firm or the lawyer will just say, like, okay, we're paid in full, so we'll just cut you a check for all the money. If they're not up to date and they haven't been paid, the lawyer will take the money that they are owed and give the client the rest. This is to make sure that lawyers get paid and that they don't get sidestepped. So what if the client refuses to pay? What if they never pay, or what if they stop paying? What do you do? Well, usually, you will send them multiple notices. Excuse me, you have not paid. And you can threaten to stop representing them. If they do not pay you. That is much easier in civil work than it is in criminal. I have no idea how that works in a criminal case. But in a civil case, non-payment is usually a justifiable reason for refusing to represent somebody, for withdrawing. Then you have the whole thing of the issue with the files and who's responsible for them. If a client owes you money for a while and they still won't pay it, you can sue them. And you sue them for breach of contract. An engagement letter is a contract, and you can sue them for breach of that contract. Sometimes you can just threaten to sue them for breach of contract. Sometimes you actually have to do it. Sometimes you sue them for breach of contract and they counterclaim you for malpractice, right? Or sometimes they just threaten malpractice outright. The thing about malpractice is the standard's pretty high, right? For malpractice, you have to really fuck it up because you, as a lawyer in litigation in particular, you make so many judgments on the fly. And it does happen. Like, I've seen it happen, but like, oh, you should have argued X when really it was Y. Like, that's not going to do it. But the thing about malpractice for a client is that when you claim legal malpractice against your lawyer, you waive the attorney-client privilege. Because the only way for there to be a discovery of whether they did the job or not is to see what advice they gave you and to see what they did, right? So it's a dangerous game of chicken to sue your lawyer for malpractice because all of your dirty laundry is going to come out. But it does happen. So I hope that was helpful. I hope that took away some of the mystery of how lawyers get paid. I know I didn't cover everything, but if you have questions, leave them in the comments and I'll try to answer them.